I'm attorney Leonard Berg, and I'm here to talk to you about the Secure Act and Special Needs Planning. The Secure Act has new distribution rules. And basically, the new rules say that upon the death of both spouses, a beneficiary has to receive the money from the IRA within 10 years. Except if the beneficiary is a person with disabilities. This person with disabilities that's a beneficiary is called an eligible beneficiary designation. It's a whole special term within the law, and don't worry about that here for the time being. But the point is, an EDB allows those IRA distributions to be spread out over the lifetime of the beneficiary. And so if you think about this, if you pass away and you have a 40-year-old child, well, if that child does not have disabilities, then that child has to receive all that IRA money within 10 years maximum. On the other hand, if the child has disabilities and is an eligible designated beneficiary, and those distributions, that disgorgement period, can be extended out over the lifetime of that individual, that child with disabilities. If it's extended over the lifetime, then each year the required minimum distribution is less, and then ordinarily that means then that there's less income that's being paid and a lower income tax. Sounds pretty good, right? Except we have to go through a few more steps here. And that has to do with the fact that, again, you don't want the money going directly to your child with disabilities. Instead, you want that money to be set aside for that child with disabilities. In other words, be sent to the trustee for the benefit of that child. So the trustee now has that money. Okay, so as I mentioned, that money that's being received plus any other earnings has to be taxable income to somebody. And if the trustee manages to bring the money in and then pay it out for the benefit of the beneficiary, for example, by paying for medical care, paying for housing, paying for transportation, all of that would cause the money to be distributed, and then the beneficiary pays the income taxes on that. And the beneficiary's personal income tax rate is going to be pretty low. But if the IRA is big enough and the beneficiary cannot actually use up all that money within the year, then that money is kept in the trust, and the trust has to pay the income tax rates. That's where the challenge gets to be. There are some special income tax rules that allow the first $44,150 of income to be exempt. Because it's a qualified disability trust. That's a whole nother little topic there. But otherwise, the very highest income tax rates, the 37% income tax rate, will kick in for income kept within that trust if the income is above, after the QDT allowance, is above $12,500 a year. So that's a 37% income tax rate is a tremendously big income tax hit. So sometimes this is going to be an issue and sometimes not. It's all going to depend on the amount of money that's going to be available for that IRA distribution. It's all going to depend on the needs of the beneficiary, whether or not you can really use the money within a single year's time. This also means that you have to have a very sophisticated trustee and who understands these rules about taking money in and then distributing it and then properly reporting it to the government. And so there may be a cost then, an increased cost for the fees of the trustee here. And you have to look to the availability of other resources as well that may be available for the special needs trust. So what's the bottom line is that you want to take care of your child with special needs. That this first indication here, oh, I can stretch it out, may be a good idea, but perhaps it's not. So you really need the guidance of attorneys such as those here at Sivia Law to really kind of guide you through all the different options. In the meantime, thank you for all the help that you provide for your child with special needs, and may you prosper.